Good afternoon, everyone. I'm sorry for the confusion in getting started. We didn't mean to be this delayed. I try to start on time, as hope you know.
Randy.
We've got several things. I want to, I know we've got two bills, or my bills, are very quick bills. We have every year what we call the revision bills, and this is only taking a bill that's taking matters of corrections and punctuation, spelling, words that are already in the code. It doesn't change any substance, so I want to get those done, and that's a year here for that purpose. Let me get you turned on with a mic, and we'll just get you to first tell about House Bill 942.
Okay, House Bill 942, first of all, there's typically three revisor bills: a general bill, a retirement bill, and an elections bill. We only have the general bill and the retirement bill this year. So House Bill 942 is the general bill. It changes mostly things like punctuation, capitalization. It's intended to conform to our code style, a lot of the things that the editors pick up and that kind of thing in page proof process. So I mean, I can go through it if you want, or if there's questions, I'll be happy to.
Not necessary. We do it every year. We
okay.
Really have very little ever come up as far as
Okay.
the question. I think one time I remember doing a committee substitute. So we'll, at this time, entertain a motion on House Bill 942. It's moved and seconded, do pass. Any discussion on the motion? If not, any amendments? No amendments. We'll call the main question. All in favor of due pass on House Bill 942 as presented, signify by saying aye. Aye. We have a due pass. Thank you.
Okay.
Next.
The next one is House Bill 944. That's the revisor bill for the retirement code, and it's done separately because it gets a retirement, since it's affecting the retirement bill, the retirement code, it gets a certification that it's a non-fiscal retirement bill. So as you can see, it's only affecting one code section, but
That's right.
it's to...
Any questions of Ms. Hamilton? If not, we'll take a motion. Motion is due pass. Any discussion? Any amendments? There being none, the main question is called. All in favor of due pass on House Bill 944 signify by saying aye. Aye. Opposed, like sign. Motion carries. Thank you,
Mr.
ma'am.
Chairman.
I know you got another committee to go to, and I appreciate your patience.
Thank you. Thanks, Jill.
We have Senator Stone. What? Pardon me?
You're doing this for 50.
In time, yeah.
Okay.
Not right now.
But you're going to, will you
We
present
don't.
one? Okay.
Senator Stone, if you would come around, I appreciate your patience with us.
Thank you, Mr. Chairman.
Happy to have you with us.
Glad to be here.
We're on Senate Bill 117, and I'll let you go ahead and, if you will, tell us about this proposal.
SB 117 adjusts the homestead exemption in Georgia. This is for debtor-creditor purposes only, and it brings it up to, in the case of bankruptcies, up to the level of the majority of states, which is also coincidentally the federal exemption level. This was the result of a study commission report in 2009 in the Senate Judiciary Committee. It passed that committee unanimously. It passed the full Senate unanimously, and it was recommended by your subcommittee. Mike Jacobs will be carrying it in the House.
All right, sir. As I recall, we did this about 6 years ago.
Well,
7 years ago.
time flies. The homestead
Last
the homestead exemption was in the closer to 2000 back.
Was it?
It was
Okay.
a long time ago. Mm-hmm.
Any questions of the presenter, Senator Stone? Senator, I don't see any questions here. Well, way to go.
Thank you.
We appreciate it. Is there anyone else who would like to speak regarding Senate Bill 117? I don't think we had anybody sign up for it. If not, we will proceed at this time, and we'll close all further public input. The bill is now in the breast of the committee. Do we have any discussion among the members of the committee? If not, the chair will entertain a motion. We have a motion due pass. Do I hear a second?
Second.
It's been seconded. Any discussion? If not, are there any proposed amendments? There being none, the chair will call the main question, which is due pass Senate Bill 117 as presented. All in favor signify by saying aye. Opposed, like sign. Motion carries.
Thank you.
Thank you so much. Next, I'm going to call on Representative Mitchell. There you go. Well, you finished up?
Well, no, but I'm here.
No, I just told you to have it by 3 o'clock.
Oh, okay.
That's the main thing. I go to another meeting. Hello, Representative Mitchell. You're here on your.
House Bill 419, great legislation.
We had this from last year. Why don't you tell us from last year what's happened on it?
House Bill 419 is before you. Thank you, Mr. Chair and ladies and gentlemen of the committee. If it pleases you, before you is House Bill 419. I must start off by saying that this has been actually a 3-year odyssey. We have certainly massaged this bill many times. That's why we today, as we sit here, we have the support of everyone that this bill affects, the industry and other groups. As you know, Mr. Chair, it has been well vetted by your outstanding subcommittee. As you also know, Mr. Chair, after massaging it, it unanimously passed this committee, got to rules the day before, crossover day, and got caught up and wasn't able to get to the floor, which brings us to where we are today. Essentially what this bill does is gives the consumer a right to cure, which the overwhelming majority of states in this nation enjoy, meaning that if you should get behind in your mortgage and you can make all the late payments, fees, and that are due, you can pay those fees. You have the absolute right to do so. And as I said, this is a right that is enjoyed by consumers, and I believe it's up to like 42 states at this present time.
Any questions of Representative Mitchell? I see none. Did you have your all right?
No, I believe the author has had difficulty getting this bill all the way through the House on prior occasions, and I hope that wasn't because of the subcommittee that it went through. I note that it went through Chairman Lane's subcommittee this time. It seems to be in very good shape, better shape than it ever came out of the other subcommittee.
Well, I was going to mention that, Mr. Chair, but
well,
in deference to our friendship, I didn't.
I thought I'd make that observation for you.
I'm going to give you every chance. What I'm trying to do, Mr. Mitchell.
Yeah. Actually, we were able to get it through last year, as you are aware. Just the timing did not favor us last year.
Hasn't been any change in the bill from last year to this year.
Actually, I'm glad you asked that. There was a change that was suggested by the industry. There was some industry insiders who felt that as a practical matter, if we allowed them to pay, if they paid, let's say, the day of the foreclosure or the day before, and they gave a money instrument that could not be verified if it was good until after the foreclosure, that would incur additional costs and the like. So from a practical standpoint, they said if you get it in 5 days before the foreclosure, then everyone could be protected. So we did adopt that language.
All right. That's under paragraph C. All right. Thank you. Any further questions of Representative Mitchell? Not, we appreciate your coming before us today. We'll see if there's anyone else in the audience who would like to speak to the bill. Is there anyone else? No one else? Then we will close all further public input. The bill is now in the breast of the committee. Is there any discussion among committee members regarding House Bill 419? There being none, the chair will entertain a motion. Have motion do pass. Do we have a second? I second it. There's a second to the motion. Any discussion on the motion? No discussion. Is there any amendments to the bill? No proposed amendments. The chair will call the main question, which is do pass HB 419 as presented. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Thank you. We don't have House Member Representative Martin's not here yet on HB 844.
He should be on his way.
He's coming? Okay. We'll hold that for him to get here. We have one other bill, which is Senate Bill 50. I have had discussions with Representative Welch, and I want to. We are wanting the parties on SB 50 to come to an agreement, and I understand we haven't reached that point yet. And I'd, Mr. Malden, when you come forward, this is, I know, of interest to you very much, and I'll ask Representative Welch, where's your mic? Would you please give us an update?
Thank you, Mr. Chairman. Out of subcommittee, this bill was heard yesterday, in fact, and the discussion was relative to the shifting of the amount of money that would be the balance of the fine that would be owed to the county, which is item number 6 on the list on the back of your bill, beginning at line 26. Previously, that under current law, that item is actually number 10 in the list. But in the committee hearing, we heard from the county representatives that specified that they would like to remain in their current position or be moved up in the list. And so that was an amendment made, was to move them up in the list and swap them out with the payments that we've made to the jail system and staffing. So that's kind of where this is played out. But as a result of that, further discussions with other folks, that amendment may have some difficulty for Mr. Malden and the amendments for the local funding of the victim assistance programs. So with that, I think probably hear from Mr. Malden.
Yes, sir. Mr. Malden, would you give us your thoughts?
Sure. Mr. Chairman, members of the committee, I appreciate being here. I'm Ken Malden. I'm the district attorney for the Western Circuit for Clark and Oconee, and I'm chair of the legislative committee for the DAs in immediate past president. So I don't want to be long-winded with as lawyers happen to be, and DAs, I guess, as well. But I usually have 2 hours to speak on a closing argument. But this started out last year. Let me back up a second. On this, the Superior Court clerks came up with this code section a number of years ago to indicate what happens if, in fact, a defendant makes a partial payment on their fine and surcharges. And for every fine, there's certain things that, if you have a base fine, there's certain things that are taken out, like some of these retirements that are like $2 here, $2 there, that kind of stuff, and maybe some other things. And there's certain add-ons, that are like the jail construction and some other things like that.
Yes.
So if you get a base fine, you get certain things. And what happened was when the 5% money for victim assistance was passed for local victim assistance, it was not on the list for some reason. It was overlooked in the 90s. So right now, unless an offender pays all of the fine plus all of the surcharges, local victim assistance doesn't get funded. It doesn't get funded at all. You can actually go into courttracks.org, I think is what it is, trax.org, and online calculator, and put in a base fine and how many months you want to pay it. It'll show you that. And you get there, if you paid over 36 months or whatever, it's at the tail end. So unless an offender actually pays that, local victim assistance doesn't get funded. And these monies are really divided up by the county. The county's the one who's deciding who gets the money, In our circuit, some of the money comes to our office for victim assistance. Some of the money goes to the solicitor's office. Some of the money goes to Project Safe. my wife is an ADA, as the chairman knows, in Greene County, and Okmulgee Circuit for another DA. In the northern counties, all the money goes to the shelter or the sexual assault center. I forgot what it's called over there. None of it goes to the prosecution community. It's really up to local controls, up to the counties to do that. So the purpose of this was simply to get it on the list, you know. And the way the list was, the base fine was kind of down at the bottom there because a lot of these amounts are smaller amounts. I mean, even on a $1,000 fine for an offender, which is unusual in our Superior Court, but even as a $1,000 fine, 5% is only $50. So if the fine basically came in and ate it up, and if the offender paid $1,000 and then was revoked, none of those amounts after that would ever get funded. So that was the purpose of having those up there. And last year, we'd come to an agreement over there, and it was presented in hearing in Senate committee on March the 7th. I think folks from the county had an objection to it. On March the 10th, there was a hearing at that time, and really what came out there was, I think Senator Hamrick, not at our request, but the county was put at the very end. And I think at that time, everybody came to an agreement with what came out of the Senate.
All right.
And so that's what I'd asked you. It doesn't matter. I mean, if the jail wants to be at number 11 and the county stay at number 10, I mean, we don't have any issue with that. But if they're above some of these very small amounts, it's going to eat up.
Well, here's my question, I guess, more than anything else, Mr. Malden. I don't want us trying to make the decision here. I don't want the committee to be the one to put the priorities of how payment. And I thought there was an agreement, which I understand there's now not an agreement. Yeah. And if there's not an agreement, I'm going to resubmit this bill to the subcommittee, and I'm going to ask the parties in interest to take this bill and have it signed off on whatever the priorities are going to be before we bring it back up. That's all
I'll be glad to do whatever. I know I spoke to Ms. Nesbitt today, and I think their feeling was they ought to be number one, and it may not be something that they can agree to. But I'll do whatever we can, because I think it's an important piece of legislation in doing that, you know. But
right. I don't feel comfortable for us trying to be the ones to say, play Solomon about this.
Well, I understand. Like I said, I thought we had, that was our understanding, and doing that. But so.
Anyone else want to address the committee on the bill before we entertain a motion? If not, the chair will entertain a motion.
Mr. Chairman, I move to recommit Senate Bill 50 back to subcommittee.
And is there a second on that motion? Second. It is moved and seconded. Any discussion on the motion? If not, the question is called. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. We'll go back to subcommittee.
Thank you, Mr. Chairman.
See you there.
Thank you. I will do it.
Next we have is House Bill 844. And Mr. Martin, you can come around. Representative Martin.
Chairman, I love your committee room here. It's one of the few places in this Capitol one you feel safe. That you have that right there behind you, so nobody can shoot you in the back.
Got a big pole there, true.
Yes, sir. I'll try to be brief with the committee. I only bought a pass to be able to practice law for the next 15 minutes before the Judiciary Committee. So if y'all will bear with me. In all seriousness, Mr. Chairman, I bring to you House Bill 844. I'm working off LC 1323, if that is please the chair. There exists a situation whereby certain bonds, the validation process can be a bit overcomplicated, and what we try to do with this legislation is simplify that to make sure that the validation process is public and formal and complete. But it also, in lines 34 through really 41 of the bill, it specifically says that and a representative of the authority doing the bonds can proceed forward with the validation. It does not, in fact, have to be, in most cases, the district attorney from that county. The district attorney in a county, for instance, like Fulton or DeKalb, Gwinnett, has quite a schedule, and it is possible to have this validation prosecuted, if that's the correct word, Mr. Chairman, without the individual in the room to do that. So that's what we seek to do in sections of the bill. We also, in line 42, seek to talk to parties that can intervene in the proceedings and how that would be done. And in lines 45 through 50, we seek some finality to the appeal process, giving the full, open, and honest process of an appeal, but putting time constraints around when appeal can be heard, and also that when there's a ruling or an affirmation given in the appeal, that be final and the process can move forward. The project for which the bonds have been issued can then move forward. Otherwise, you can get to a situation where it slows a project down, or you have bonds that have been out there and then somebody comes back, and I believe it can lead to quite a complex situation for the bonding authority and the buyers and holders of those bonds. Mr. Chairman, I again, in all honesty, I'm not an expert in bond. I think there's a number of people that can speak to this in some of the technical areas better than I, but I would present the bill to you and try to answer any questions that you or the committee members may have, and also direct those that I am not able to answer to some more learned professionals than myself.
Any questions of Representative Martin by committee members? Apparently there are none. Thank you. Let me, you can apply it over. I want to make a comment to the committee before we bring in the next. There's one other person who wants to speak on the bill I know of. I had a call from Representative Hatfield, who apparently had surgery done on a hand today, a finger. He had apparently a torn ligament and had to have it operated, so he could not be here. He expressed having an interest in the bill as to matters that arise down in his area around Waycross, Ware County. And they're a development authority. I don't know what they exactly are. I told him I would bring that to the committee's attention, and based upon that, we can either delay and let him address it on Thursday when we have our next meeting, but I'll leave that up to the committee. In the meantime, I know we have Lewis Horn, Mr. Horn, who's a practicing attorney. If you'd come forward, and we'd like to hear your comments. Have a seat right up here.
Thank you, Mr. Chair.
Thank you, Mr. Horn. Glad to have you with us.
Okay.
Why don't you tell us a little bit more of the background, and I know you represent the Development Authority of Fulton County, among others, but tell us what has been the concern and why you felt this needed to be something addressed by legislation.
Mr. Chair, members of the committee, as the Development Authority has been through a number of challenges to bonds, the need appeared for us to address certain procedural inconsistencies. And these are only to answer questions that often come up in front of the judges in contested validations. And these inconsistencies are purely procedural and are not intended, I think in good faith we can say, are not intended in any way to change the levelness of the playing field. And if I might, sort of in going down the list, the first one relates to the district attorney. The revenue bond law says that the district attorney is obliged to file a petition, but it gives no further instructions regarding the role of a district attorney in a bond validation proceedings, whether contested or not. As a result of which, I've been doing this for 30 years, 99.9% of the time the district attorneys don't appear in the bond validation hearings and basically let the appointing authority go forward. And that has now come up to question as to whether or not the district attorney, as representing the state of Georgia, is obliged to appear, and whether the absence of the district attorney could invalidate the bond validation proceedings. The second one is for, in the Georgia Supreme Court ruled in 2009 in a case called Sherman versus the Fulton County Taxpayer Association, and it recommended that certain documents, although the law says you should seek to validate the bonds and the security therefore, the Supreme Court suggested that ancillary agreements such as tax agreements could have been validated. And to the extent that that seems to be, the Supreme Court went further than the existing statutory law, the suggestion was made that perhaps the statutory law should be expanded to follow the dictates of the Georgia Supreme Court, and to say that the bonds that you shall validate the bonds and security therefore, including any ancillary or related documents relating to the, as the court deems appropriate.
Address, if you would, Mr. Horn, what are those ancillary type documents? What are we talking
In some instances, the bond purchase agreement is not validated because it's not considered part of the security for the bonds. In some of the deals which are past tax incentive bonds, there's an agreement with the tax assessors relating to the taxation of the property, and that's not validated, and that has not been a practice of validated, but the Supreme Courts appear to open the door and suggest in the court that and it said that, and in fact it used the language any ancillary or related documents. So the idea was to the extent when you present this to the court, to a judge in a validation proceedings, there's the law and then there's a Supreme Court ruling, and we suggested that the law be brought up and to be made to read consistently with the Supreme Court.
Okay. Most of your, again, you mentioned the purchase agreement. Most of these bond validations going through a development authority are dealing with one purchaser of the bonds, correct? Usually the party who is the new business or expansion of business. That bondholder will be also the user of the funds, correct?
Only in tax incentive bonds, sir. And the development authority does taxable and tax exempt bonds. If in most tax exempt bonds, the development authority, the bond purchaser could be a Wall Street investment banking firm, a public issuance, or whomever. And in those instances, very often, the bond purchase agreement is not signed until the validation. You're permitted to validate bonds on a parameter basis, not to exceed a certain interest rate.
All right. I didn't mean to interrupt you. Go ahead.
No, sir. The third one is the party to the validation. There's a inconsistency in the law because there's a law, Civil Practice Act speaks in terms of procedures for intervening in a bond validation, and calls and speaks and says that in order to intervene, particularly if you're a lawyer, you have to file some documents in advance. You have to let the judge know why you're intervening. In some of our recent deals, also, but the revenue bond law indicates that any party wanting to appear can come to court and become a party. Well, the question then arises: if someone becomes a party, are they an intervener? And we've had situations where someone comes to a court, files a motion to become a party rather than intervener, then calls themselves an intervener thereafter, but doesn't give the court the benefit of their arguments on the front end. And in talking to some judges and all of that, they said this is the one instance where parties can come to court without following the rules for making themselves a party, and that it would not be an onerous requirement to have them go to the clerk's office and file something and fill out, even in longhand, the necessary documents to become an intervener.
How will they become a party under the current law?
They can just show up. And if they show up, they're entitled, if they can show up, it's not clear whether or not what their role, they can become a party, and once they're a party, they can appeal. But the question arises is it's difficult for the judges, because if you're an intervener, you're required to file your rules for your reasons for intervening.
All right.
And then finally, Mr. Chair, number 8 is the last one, and this goes back to my aforementioned discussion of the Georgia Supreme Court. The Georgia Supreme Court suggested that certain ancillary and related documents could also be validated, but the court also suggested that to the extent that the bond validation would be valid only to the extent of all of the documents validated. So this raises the question that it raises the question regarding the finality of bond validations. Typically, and heretofore in the past, bond validations, bonds once validated, were deemed inviolate. That in fact they could be purchased by anyone, anywhere, and once they were validated, even absent, even including fraud, they could, in fact, the purchaser could rely on the opinions of the parties and in fact purchase the bonds. In this instance, to the extent the Supreme Court rule was focusing on these other ancillary documents, the question arose and could be possibly interpreted that if there was a document which, quote unquote, which conceivably could have been validated and was not, then that might lead to an ability of a party to then unravel a bond transaction when bonds have been in fact been validated and sold to innocent third parties.
All right, sir. You have some questions of the members of the committee, and I'll first recognize Mr. Jacobs.
Thank you, Mr. Chairman. Mr. Horn, you and I have encountered each other once
Yes, sir.
before in exactly this situation. And I want to kind of understand your take on how on how a party who wishes to become involved in a bond validation proceeding by virtue of raising a question of law is not following the procedure. I mean, they may not be intervening formally under the Civil Practice Act, but I think that the existing procedure in 368277 is quite clear that because you've got to advertise your bond validation hearing, correct?
Yes, sir.
And it's advertised for a date certain and a time certain in a court of law, correct?
Yes, sir.
And then the bond validation law gives any citizen of the affected jurisdiction the right to come and raise a question of law.
Yes, sir.
Now, you'll recall that I was actually a party who did exactly that,
Yes, sir.
correct? And from experience, it seems to me that it didn't cause any kind of a problem because what the judge asked at the time was for the parties to brief the question of law, and then he ultimately decided it with a written order after the briefing occurred. So I guess my question is, because that was a valid question of law that was raised according to this procedure, the court found for the intervener in that situation or for the party raising the objection, that case went up on appeal to the Supreme Court, and the Supreme Court agreed
Yes.
with the trial court, correct?
Yes, sir.
So what's the problem?
The problem is, and there's no problem with your situation, the problem is if someone comes to the court and asks to become a party and admits not having read the documents and then subpoenas 15 people, then the judge has to go, the judge there has to decide on whether or not those parties could in fact, those subpoenas could be quashed. The problem is that the judge has no basis on which to argue to determine whether or not the parties are proper parties to be heard in the subpoena because there was no document filed on the front end. There were no legal questions presented. In your case, you were there and you were willing to file briefs on the front end without witnesses. In this instance, it becomes a procedural morass where the judges sit there and don't know how to proceed. I mean, this was recommended by some of the judges because the bottom line, they don't know how to refer to someone who's, is he a party, is he an intervener? In very instances, someone will file a document, ask to become a party, and then define themselves as intervener thereafter and follow the dictates of the Civil Procedure Act. And that's the only question is that, that it's totally open for a party to come in and make any claims, but you've got to be on one side or the other. You've got to be either following the rules or following or sort of making your own rules.
Well, I mean, I don't have a problem with the rest of what the bill tries to do, but I do think that paragraph 7 throws up a procedural roadblock to the average citizen that might come and raise a valid objection. I mean, I understand sometimes this is abused, but I think also sometimes citizens can show up, and I mean, at the end of the day, you're talking about a bond validation that I think the citizens of the jurisdiction have an interest in, and that there's no absolute right to have those bonds validated if they don't comply with the law. So, I mean, ultimately, I would hate to be throwing up a procedural barrier to citizens being able to show up and make a valid objection. And I think that the invalid or the frivolous objections, I mean, the Superior Court judges should be able to see through that. And address it post haste.
If only. And I agree entirely. In fact, I'll just tell you that not being a litigator myself, I was uncertain about this provision. But talking to the judges, they said if a party comes in and says, I want to speak on the bond validation, then all they need to do is be directed to the courthouse and file documents and basically they can fill it in by hand and become an intervener and follow the rules. It is only just the idea is this is an opportunity to prevent the judges from being ambushed, because in terms of turning a bond validation into a full evidentiary hearing without any basis for determining what the questions of law are.
And I guess my concern is this: that ultimately, you know, I'm a lawyer and I could have filed a motion to intervene, no problem. Now I didn't do that, but it worked out well anyways. But for the average citizen that shows up, I think what that paragraph does is throws up an unnecessary procedural roadblock. Given that it may end up being someone who has found something in the law that they would like addressed by the court, but may not have read the Civil Practice Act and may not have a lawyer. So I'm actually very concerned about paragraph 7. The rest of them I don't have a problem with.
All right, let's next, Mr. Welch.
Thank you, Mr. Chairman. Tell me again your name.
Lewis Horn.
Mr. Horn.
L-E-W-I-S.
Thank you, Mr. Horn. I have the same concerns that that Vice Chairman Jacobs has. Somewhat from the other perspective, I do a lot of this work with local municipalities and water authorities, school boards, etc. But I do have the concern that this language in paragraph 7, I'm not sure if this would require the filing of an intervention before that very initial hearing, the validation hearing. This doesn't seem to make clear to me whether or not the procedures are going to be triggered prior to the hearing, or whether or not that would occur. A citizen attending the hearing could raise his or her objection, and then the court could hold the matter, reschedule it for another hearing date, and then allow the person to intervene. And I don't think that in my practice, what has happened is that whenever someone has raised those objections, the Superior Court judge has simply just rescheduled it for a different hearing, set a different hearing date to allow the parties to brief the matter and to file the necessary pleas. I think this language creates a question in my mind, and it creates confusion that could be construed by courts on appeal later, that if a person attends the validation hearing, raises an issue and an objection to the validation, that they would be barred from raising that objection if they had not followed the Civil Practice Act and filed the proper documents for intervention. That's the construction that I think I'm hearing you say, and that's the construction I think I would have if I was concerned about this going to the Court of Appeals to be reviewed. So I have similar concerns that Mr. Jacobs has with this language.
All right. You want to respond to that? Or?
No, as I said to Representative Jacobs, initially when I thought through and worked with my very number of other lawyers and colleagues about this, I worried, and as I said, I wanted to present something procedural that would not change, any way tilt the playing field one way or the other. And we wanted to focus on inconsistencies in the law. And as I said, I don't know, one of the biggest inconsistencies now, if someone comes in who is a lawyer or without a lawyer and comes in and says, I am making myself a party to the transactions, and thereafter becomes an intervener, calls themselves an intervener and follows the Civil Practice Act, have they in fact double dipped? Have they, it seems to me, and then based upon the recommendation of other judges, then the question is, they said it would not be too onerous to require someone who wants to intervene, wants to become a party to bond validation procedure, to go in and ask the court, how do I intervene? And they would be directed to the clerk's office to file a document. And the only thing I would add, this only relates to the development authority. What we've tried to do is a change to the revenue bond law relating only to development authorities, and to the extent it doesn't apply to water authorities or anything else. But the idea is the development authorities with the private projects that they do.
You have the same thing, though, that can occur under those other type bonds?
Yes, sir.
Somebody can come in as
yes,
a party?
Sir.
Okay. Ms. Stevens, glad to see you.
It's good to be back, Mr. Chair. My question also relates to paragraph 7. Under 91124, under intervening, Attorney Horn,
yes, sir.
Is it your understanding that the party who complies, because the question I had was similar to Attorney Welch, the intervention would just mean you have to file the prerequisite papers so that there is no surprise on behalf of those that have to defend the evidence that's presented at the validation proceedings. Is that correct?
Yes, ma'am.
Okay. Then,
as well as the judge.
Well, right. Well, the judge has to make the decision, but the surprise is on behalf of those seeking to have it validated, correct? And if, in fact, the intervention intervener who has to have some kind of standing had to comply with some regs, then this would eliminate the continuance or the stopping. You just go and file for intervention so that all parties has notice.
Yes, ma'am.
That's my understanding of 9/11/24.
Yes, ma'am.
Okay. Thank you.
All right, any further questions? Mr. Horn, we appreciate you coming
All
and
right.
being with us today
Thank you
and
very
helping
much.
explain how it happens in the real world. Is there anyone else who'd like to address the committee on House Bill, lost number, 844? If not, we'll close off further input from the public. The bill is now in the Breast Committee, and I'll raise a question about what I presented earlier about Mr. Hatfield, if y'all take that in consideration, what you want to do.
I'll move to pass, Mr. Chairman.
The motion is due pass. It's been seconded, and we have a, are there any motions, any discussions on the bill or any amendments?
I have an amendment, Mr. Chairman.
All right, state your amendment.
That would be to strike paragraph 7 in its entirety, insert and at the end of line 41, and renumber paragraph 8 to become paragraph 7.
The moved and seconded to amend as stated by Representative Jacobs. It's been seconded. Any discussion on the amendment? If not, any other amendments? No further amendments. We'll take the Jacobs amendment first. All in favor of the Jacobs amendment signify by saying aye.
Aye.
Opposed, like sign. One objection. Chair rules the motion carries. Any further amendments? No further amendments. We go to the main question, which is a due pass House Bill 844 as a committee substitute as amended. All in favor signify by saying aye.
Aye.
Opposed, like sign. And motion carries. Thank you.
That's good.
But that concludes the business for today. I want to remind all members that this Thursday we're going to take a very important issue up, and that's going to be the bill pending on the juvenile code revision, and would like to get everyone here if possible for that. It's going to be a matter of, I think, important for this House to take under consideration. Thank you. Thank you.